Good afternoon, everyone. I'm Don Liu from Shanghai Jingmao Law Firm. It's my honor to be here to present the legal risks control of the investment in China. Here is a short introduction about my background. My practice areas include foreign investment, M&A, litigation, and arbitration. Today's topic will be discussed from 4 aspects. We will firstly get a rough glance at the recent situation of the foreign investment, and then we proceed to the legal risks and the control, and then is a conclusion. Now let us have a look at the recent situation of foreign investment in China. Since China's reform and opening up in 1978, China has become a hotspot for foreign investment. More and more foreign investors are engaging in different kinds of economic activities in China. Let's have a look at a chart. According to a statistic report of FDI in China in 2019, issued by the Ministry of Commerce, as of 2018, a total of 960,725 foreign investor companies were established in China. In 2018, China regained its position as the second largest recipient of FDI in the world, with US $138.3 billion FDI, and accounted for 10.7% of the global FDI inflows. As China's economic and trade financial center, Shanghai is inevitably the first choice for foreign investment. In April this year, despite the severe situation of the global COVID-19 epidemic, there were still 21 regional headquarters and 10 R&D centers of multinational companies established in Shanghai. Apparently, despite the complex international situation, the foreign investment in China is booming. However, the legal risks of investment in China should not be ignored. This part will be discussed based on the timeline from the following aspects: the preparatory stage and the operating stage. And each of the stages may exist special risks. When foreign investors want to invest in China, it should care about legal risks. In preparatory stage, the first one is the risks of access, which include industry restrictions and pre-approval. Industry restrictions, just as its name implies, not all industry and fields are open to foreign investors. For example, wholesale and retail business of tobacco products are forbidden to foreign investment. Although some industries do not restrict the entry of foreign investors, there will be special requirements for share ratio, such as cinemas, talent agencies, domestic water transportation, publication printing, and other industries, which need to be the Chinese side holding. As for the pre-approval, before engaging in some special industries, foreign investor companies should obtain prior approval from the government according to the Chinese laws in order to handle industry and the commercial registration and carry out relevant business activities. For example, security service need to obtain the corresponding license first. Once the relevant business activities are carried out without a license, they may have to face a punishment. The second aspect is the risks in the form of investment, includes WOFE and the JV. The full name of the WOFE is a wholly foreign-owned enterprise. Generally refers to an enterprise established in China with capital fully invested by foreign investors. The advantages of WOFE are the absolute control and the decision-making power over the invested enterprise, to ensure the strong executive power of the invested company. The shortcoming of Wolfie are foreign investors may not have a deep understanding of China's economy, culture, and the market conditions, which may cause increasing risks during the management. As for the joint venture, also usually we call it a JV, generally referred to an enterprise jointly established by foreign investors and the Chinese companies, enterprise, or other commercial organizations. The advantage of JV are the full use of the resource of both parties and the mutually reinforcing, which are helpful to the rapid expansion of business in China. The shortcoming of JV is the weak control over the company by the foreign investors and the potential and the possible disputes between the two parties over the distribution of interests. Now we are going to discuss the risks of JV. Before the establishment of the company, foreign investors need to choose a Chinese partner that may face risks of partner selection. When choosing JV partners, foreign investors may not fully understand the status of JV partners in the investing field, which causing the JV less competitive, or fail to know the financial condition of the JV partner. Thus, facing the situation that JV partner cannot make a capital contribution on time, or cannot make additional investment in later period, or they do not conduct an investigation over partners' lawsuits, which having a negative impact on the operation of the JV. Of a smart choice of partner, there will still exist risks of corporate governance. According to the latest foreign investment law, the corporate governance structure and the standard of conduct of a joint venture should be subject to the company law. As the authority of the company, the shareholder meeting decides the major issues such as profit distribution and the investment plan. If the Chinese investor and the foreign investor in JV each hold 50% of the voting rights at the shareholder meeting, the deadlock may occur if there is no special agreement in the Articles of Association. The members of the board are elected by the shareholder meeting, and generally the number of directors is odd. However, in order to balance the board, some companies adopt an even number of directors, which may result in the failure of the resolution when it is required the consent of more than half of the directors. The directors recommended by one party and elected by the shareholder meeting usually represent the interests of the recommending party. Once the proposal of board is unfavorable to one party, the directors recommended by that party may be absent from the board meeting, and the board meeting may not be held and voted on this situation. The following part will focus on the legal risks in operation stage. During the contract performance for a foreign invested company, the counterparty of the contract may delay the performance of the contract for various reasons, or the performance may be defective, or the contract is unable to perform, thus causing losses to the company, or the contract signed by both parties are not clear, and the description of rights and obligations are vague, which may lead to a different understanding of the contract between the parties and result in disputes. Moreover, there are risks of compliance during the company's operation. The first one is the risks of monopoly. A foreign invested company may enter into a monopoly agreement with a competitive operator for commercial interests. Once it is identified as a monopolistic act by the government may impose a fine on the company according to the anti-monopoly law and have a power to confiscate the illegal gains. Also, there are risks of unfair competition. In order to expand the market, foreign invested company may conduct marketing. However, sometimes the marketing behavior may damage the rights and interests of other operators or consumers, such as confusing acts that enable people to mistake its products for another operator's products, or believe certain relation with others, which may be considered as unfair competition behaviors and may cause results. Regarding the illegal acts, such as fines, confiscation of the illegal gains, civil compensation. Here is a case about the unfair competition. An e-commerce technology company during the operation, it's notable, used the logo of the TikTok e-commerce and the TikTok graphics on the decoration in its business site and its publicity posters, which was mistaken by public as having specific connection with the owner of the short video app of TikTok. In the end, because this Commerce Technology Companies Act is identified as confusing behavior, which is enough to cause people to be mistaken for other people's goods or have a specific connection with others, the government ordered it to stop the illegal activities immediately and impose a fine of RMB 320,000 yuan. Besides, there are still risks of intellectual property infringement. If a foreign invested company uses the intellectual property right without the permission of the right owner, the foreign invested company shall bear civil liability. According to the copyright law, if neither the actual loss of the right holder nor the illegal gains obtained by the infringer can be determined, the People's Court shall decide to award damages of up to RMB 500,000 yuan, according to the situations of the case. If the infringement damages the public interests, the Copyright Department may take punishment such as warnings, sanctions, confiscation of the illegal gains, and the confiscation of the infringed products. With the improvement of the China legal system, the punishment for illegal acts in the law are constantly increasing. In addition, for foreign invested companies, there are also potential risks in labor, taxation, land, and other aspects. We talked about the legal risks in the past few minutes, and now they come to the control of the legal risks about investment in China. This part contains five aspects based on the timeline of the foreign invested company from foundation to daily operation. Back to the foundation of the company, the important matter are negative list and share ratio limit. The government issues negative list every year. Foreign investors should learn the annual negative list before investing in specific industry in China to avoid investing losses. For industries that are excluded by the negative list, it is also important to look through the relevant industry laws and regulations in advance to find out whether there is any restrictions on the share ratio of the company. After making it clear the entry restriction, it is necessary to conduct due diligence. When selecting joint venture partners, foreign investors should entrust professional institutions like law firms and accounting firms to conduct due diligence in advance, to have a detailed knowledge of the background, financial condition, lawsuits involvement, and other aspects of joint venture partners, so as to ensure the best joint venture partners can be selected. After foundation of the company, it is necessary to improve the corporate governance. Foreign invested companies should establish a perfect corporate governance structure and clarify the discussing rules and voting procedures regarding the general matters of the shareholder meeting. For the resolution about modifying the articles of association, change the register capitals, or the special matters concerning the merger, division, or dissolution on the basis of not violating the company law, it is necessary to consider increasing the proportion of the voting rights based on the actual situation. To avoid the deadlock in the board meeting, the number of directors should be odd. Both parties to the JV can recommend the candidates, and the directors should be elected by the shareholder meeting. Foreign invested companies shall make clear the selection rules of the chairman and the vice chairman. Besides corporate governance, establish a compliance system is important to company. What's more, the company should establish corporate compliance values. Foreign invested companies should start from the top down and the management level to establish, recognize, and attach importance to the value of compliance and build the compliance into enterprise culture. Further, the company should put the compliance value into the practice. Companies should make relevant compliance standards, manuals, regulations, guidelines, and other regulatory documents. Meanwhile, these guidelines and regulations should be published in the enterprise in written form. That's all employees know very well. Meanwhile, companies need to set up corporate legal and compliance departments. Foreign investment companies should set up special legal and compliance departments with professionals. The policies, plans, and the measures should be examined and approved by the professional legal and compliance specialists in advance. When facing disputes, companies should make use of the dispute resolution system. For the dispute with official organ, complaint method can be used. If a foreign investor company or its investors believe the acts of official organ or personnel infringes its legal rights and interests, it may apply for a solution through the complaint system or the foreign invested enterprise. For the disputes with civil subject, company can find a solution through litigation or arbitration. Foreign investors can agree to settle the relevant disputes by arbitration in the contract. There are several arbitration commissions in Shanghai, such as Shanghai Arbitration Commission, Shanghai International Economic and Trade Arbitration Commission, the China International Economic and Trade Commission, Shanghai Sub-Commission. The arbitrators may be selected by the parties individually or jointly. If the arbitration is not agreed upon, foreign investors may also be settled disputes through litigation. Now, the judicial environment in China has also improved. Remarkable. Now it comes to the conclusion. Despite the objective existence of legal risks for foreign investment in China, in general, these risks can be controlled and avoided with the execution of the foreign investment law and its relevant regulations. From January 2020, China is becoming more open and inclusive to foreign investment and lay more emphasis on the protection of them. The investment environment for foreign investors in China is becoming more friendly. In the future, there will be great opportunities for foreign investors in China. That's all my today's topic, and I really appreciate your attention. Thank you.